I want to start with the Supreme Court. I promise I'll get to Trump, but we have a lot of stuff to get to. And I'm not going to start with the Alito flag, but we can maybe touch on that. I do want to ask you about the case that relates to the South Carolina redistricting, because these are the representatives that South Carolinians would then send to Congress to represent them. So the districts and the way they're drawn, the gerrymandering, is very much a part of who ends up having the power in the state of South Carolina, who gets the most representation. The Supreme Court has overruled a lower court that said the gerrymandering in South Carolina was too intense and racially biased.
Well, this was a 6-3 decision. It was actually written by Justice Samuel Alito in the unedifying spectacle that all 6 Republicans voted in a way that really helped the Republicans, the 3 ones who were picked by Democratic presidents, voted in a way that would have helped Democrats. And there was a 3-judge trial that was held in South Carolina where there was extensive evidence, Mark. And the issue was, first of all, do you assume that legislators, when they redistrict, are acting in good faith? And the answer is yes, you assume that they're acting in good faith. And so then the question is, did they base this change on race, or did they base it on Democratic voting? They claimed throughout all the evidentiary hearings and trials of this matter before the 3-judge federal court that it was just based on Democratic voting statistics. Charleston has a large Black population, and it votes generally very Democratic. What they did is it was a swing district, very close. It's the one that Nancy Mace, who I saw on Bill Maher and who's become sort of a celebrity in Republican politics, she was sort of the elected in this swing district. And either side could win it. And that was why she was pretty moderate at that time. What the Republicans did, who controlled the redistricting process in South Carolina, what they did is they took about 60,000 voters who were Democratic voters, and they stuck them in a very heavily Black district. So that made that heavily Black district not 80% Black, but 90% Black, not 80% Democratic voting about, but 90% voting Democratic. And that left Nancy Mace's district with about a 12% Republican majority. Voila. What used to be a swing district, very winnable by a Democrat, became like a 62% Republican district, sure to be won by Nancy Mace. As soon as that decision came along that way, Mark, guess what? Nancy Mace started to be a big Trump backer, right? Because with a 62% Republican majority, she could do that. So the 3-judge court said, no, we don't believe, despite all the evidence, that you were acting in good faith. We find, based on this huge evidentiary record, we find that they were picked because they were Black. Now, you might say what difference it makes. But under the Constitution, there has to be equal protection. Under the Voting Rights Act, there are certain protections for Black voters. And so those two can be in tension. In fact, a case very much like this, Mark, came up 7 or 8 years ago. RBG was then on the court, and the court said, no, this almost same or parallel situation, we do not find that they were acting in good faith. We find that they did pick voters, not because they were Democratic voters, but because they were Black. And they stuck them all in this district, and that failed to live up to the Voting Rights Act. Now, without RBG on the court, the way it's voting now with Barrett, 6-3, they overruled the 3-judge federal panel, and they said, no, this is just fine. This 62% Republican district can stand. And that's it. It's very disheartening, but that's what just happened today.
Yeah, that's breaking news of the moment. And as you say, it's both disheartening and it's politically partisan based on any kind of objective reading of things.
That you can do. If you're only politically partisan, that you can do. If you're discriminating against Black voters as Black voters, that violates equal protection.
I see. From the legality of it, I guess that's it. I don't mean to diminish that. I'm just suggesting that philosophically you could see what was happening. I mean, it's a power grab. And then, so staying on the court with this Supreme Court Justice Alito and more revelations about these flags. I guess this guy really likes flags. And his latest is this second flag, which was a symbol for a hard right religious position that was part of the Stop the Steal campaign. In other words, the flag was present at the J6 riot. And, this is not the upside down American flag. This is a different flag. And it was flown by Alito. Now, he hasn't produced the, I didn't know about the flags, my wife handles the flags type explanation on this one. But I'm wondering, are we making too much of this, David? I don't mean to be, I'm clearly against this guy as a wild partisan, and he represents everything wrong, I think, with the country these days. This is my position, my opinion. But are we being too harsh? Should he be allowed to fly whatever flag he wants, even if it's a controversial one?
Well, when Alito first went on the U.S. Supreme Court, there was a big reception in Washington, D.C., at which both he and I were present. And the photographer caught us at an angle where he thought we looked enough like each other that he ran a photograph with the line "separated at birth." So I want all of your viewers to know that you have David Katz, not Sam Alito, on your program. Someone actually pointed that out to him, another former law clerk for my judge. He was pretty drunk at the time. And he said to Justice Alito, "I've always said, Your Honor, that you and my friend David Katz look alike." And Alito said, "No, your friend is much better looking." So I'm sure he's a personally charming guy. They said that Rehnquist was the most charming person you'd ever want to meet. But no, Alito is he's all wrong on this, Mark. A judge and a justice, they have to fight against any biases that they have. And they have to project to the public that they're fighting against those biases in good faith, doing it hard, taking it seriously, not just voting their political and philosophical preferences. And to throw it in the face of people with a flag like that was brandished right on January 6th in this riot and marauding. 5 people died. They almost overturned an election and our democracy and the peaceful transfer of power. To put up their flag.
You can see 2 of the flags there in that picture, one lower left and one lower right.
Right. And to put up those flags, and the whole world knew that those flags had been unfurled and shown at the January 6th riot because the whole world had seen those pictures. And, if he's going to blame this one on his wife, too, it's just really it's what's the word? It's stand up, be a man up, say, look, I put the flag up there. It was terrible judgment. But now he's kind of stuck, right? Supreme Court justice or not, once you start telling a story, the story may catch up with you. If his wife put that one up, what was he lying then? Is he lying now? Is he clamming up now because he gave an explanation that's kind of gone awry the first time? And of course, there's no code of ethics for the Supreme Court that has any teeth that anyone can enforce. We've talked about that. And this is just showing both him and Thomas. He's also, some people call him Salmon Alito because he went on that huge junket to salmon fish out in Alaska, and he said there was room on the plane. So, Mark, I know what you and I are both doing now is we're inviting these people with these huge private planes and reminding them that there's an extra seat, and they're taking you and me to Alaska. We don't have a swing vote on the U.S. Supreme Court, but they're taking us to Alaska, right? It's smarming.
It is. It's open corruption. And in this case, as you suggest, it reflects a political bias and a philosophical bias that we've known about. But to have it in your face like this, even Clarence Thomas didn't drive that huge RV bus that he was given. He doesn't drive it to work every day. He doesn't put it in our face. And he is another level of corruption. Huge payoffs and the property purchase for his mother and all this sort of thing. But again, just to review, Alito is that guy who, in that commencement speech, says the freedom of religion is imperiled in this country. So he is making decisions for the hard right and really answers to the religious right in a way that I think we'll continue to see reflected in his decision making. I want to get also to some other cases, and then I will get to Trump at the end, I promise everybody. But there was some news of the moment that was related to monopolies and breaking up the power of a major broker when it comes to live entertainment and tickets. And that is Ticketmaster and Live Nation. Now, this is not a Supreme Court case, but this was a a situation where the Justice Department is moving against these various companies that they feel either reflect a monopoly or are close to being a monopoly on the various areas in which they operate. Can you speak to that?
Mark, this is Live Nation Entertainment, the huge one, the dominant one. They are a monopolist.
And the notion here is that they not only control the venue, but they control relationships between the ticket selling for the venue and the performer at the venue and the venue itself. Meaning, if you control all of these things, you have incredible leverage to force all kinds of deals when it comes to how much compensation an artist gets, how much compensation a ticket broker gets, or in other words, you control all aspects of this. This is a monopoly, as you say.
Well, in 2010, this was when Obama was president. And it's not a knock on Obama. He did a lot of things that I certainly agree with. Obamacare to start off with, which the nation needed for all of those decades. But this is one of those things the consumer groups told him at the time that he should not have his attorney general for the for antitrust enforcement. They should not approve this merger. And they approved the merger over the objections of the usual consumer groups that said that this was going to stifle competition, it was going to lead to a monopoly, and it would drive up the prices of tickets because the tour promoter, and they also did a lot of handling of management of artists. So they would have the tour, they'd have the management, and now they were the ones selling the tickets. And so obviously they could exclude competitors. And they did. And the reality is that there has not been more competition in that field. The price of tickets, as everybody knows, has skyrocketed. And these groups, they don't even need to be threatened, Mark, because they give in, because they know if you're going to do, let's say, 30 different venues, and you're going to have Live Nation promote it, and you may give them a hard time about whether Ticketmaster is going to handle the tickets, somehow or other, they know they're going to be bad results. And we've seen the prices go up, and we've seen there be less competition. And now with the Justice Department, this is Merrick Garland now. He just issued a statement which he said that this Live Nation has to be broken up. It has. This is antitrust law. They broke up a lot of the big monopolies. They broke up the phone company. That's why we have so much competition in phones and so many great strides forward with our phones and iPhones and everything else that never would have happened if they hadn't broken up the monopoly that the old phone company used to have. And so I think it's important, I agree with Merrick Garland on this, that at the very least they should have to divest, that is to spin off Ticketmaster. So yes, they can promote their tours and they can do management, but some other company, some completely separate company has to handle the ticketing because they just have too much power and they exclude competition and they drive up prices.
Yeah, and again, just to reiterate, Live Nation owns Ticketmaster, so it's that's why we talk about them as separate things, or I do anyway.
That was the merger that was approved in 2010 over the objections of the consumer agencies. It was approved by the Obama administration, and that's what happened. It's not like nobody predicted this was going to lead to exactly what it led to. A lot of people said that it would. They said they'd have really tough enforcement. It probably didn't help that they had 4 years of Trump. You can't imagine that there was much enforcement of the supposed enforcement mechanisms under Trump. And here we are. I don't think I need to tell people the prices are astronomical.
Yeah, I mean, you complain about prices, guys. This is what happens when you don't have any regulation. These are corporate regulations. These are corporate protections. You can call them regulations, and there's this stink on regulations, but these are protections. There are protections for the environment that are associated with regulators. There are protections for consumers that are associated with the regulators. And just as we spend a beat on this, David, I want to mention that Apple is being sued by the U.S. government, Google is being sued by the U.S. government, and Amazon's being sued by the U.S. government. These are all cases that are similar, and I wonder if you could remark just on this sort of general attempt to rein in some of these huge corporate entities by a government right now, an administration right now, that would seem to be at least a little bit more consumer friendly.
Well, this trust busting started under the Republicans, who were the progressives then. Teddy Roosevelt, huge trust buster. But it just seems that now the Republicans are not that into it. which they ought to be, because as the self-proclaimed party of small business, small business gets completely crushed. Think of every small business that's been crushed from all of these trusts, going back to the railroad trusts, all the famous one, Carnegie and the Steel Trust. And now, of course, we have these trusts right now. So I think it's another reason to vote for a Democratic president and to reelect Biden, because he's doing something about this. We didn't hear about vigorous antitrust enforcement to help consumers and to help the little guy and to help small business. Yes, small business. You're getting crushed by these huge corporate takeovers, and then you get excluded from business opportunities. You hear about how, like, the advertising, I haven't really followed it closely, but apparently these huge social media companies, they totally disfavor certain people. They bring others along. People say they're not, the kind of allegations that they're making against them. So these efforts by Biden and his administration, I think, are very, they're well taken. And I think all the lawsuits that I've heard about so far to break up these big companies, to make them divest things that make it less competitive and that raise prices for the consumer, I think they're all for the good. And I think that nowadays, at least, it's the Democrats who are looking out for the little guy and small business in this antitrust area.
We have insanely corporate-friendly justices on the Supreme Court. Couldn't this all just be appealed to that level?
Well, yes, but they have antitrust laws that if the administration enforces them, it's hard to imagine the justices, overruling antitrust enforcement. There'll usually be a trial. The trial will find the anti-competitive effect. Just like with South Carolina, there is an assumption of good faith by the government. So it's hard for the person attacking it, like, let's say, Apple or Live Nation, end up losing one of these cases. And yes, they're going to try to scurry to the U.S. Supreme Court with, their incredibly good lawyers. But at the end of the day, they have to show that the administration, made some error. There was some problem in the findings, that they weren't acting in good faith. And so when you look at justices like Roberts and Barrett, I think that they would go with the other three. If there's a good record, they would affirm the breakup. And then sometimes these companies agree to it. That's what you have to. Live Nation actually agreed to what happened back with Obama in 2010. And they said there'd be all these tough regulations, and the tough regulations weren't enforced. And that's been pointed out. And there were also some Senate hearings where actually these anti-competitive actions by these huge corporations, they said, you've done one thing that very few people can do: unite the Democrats and the Republicans in the Senate, saying that it's an outrage what they do with prices and how they stifle competition.
I want to now pivot to a listener question. I want to try to find it. Question for David Katz from Debbie. I encourage everyone and remind everyone that you can email us, and I will integrate any questions you have or remarks you have that you'd like me to push to David at themarkthompsonshow@gmail.com. themarkthompsonshow@gmail.com. So Debbie writes, question for David Katz. If a jury in the Trump trial returns very, in capital letters, quickly with a decision, or takes a very long time, in capital letters, to make a decision, can either time factor in the Trump case have an impact on the judge and his decision for sentencing? That's interesting. I would first ask you, can you tell anything by the length of deliberation, and then speak to the judge and the leanings?
Well, one thing that's been remarkable to me, because you have a jury that's not sequestered, and you had all these issues, including with the gag order. Trump was not supposed to talk about the witnesses, even the witnesses who were talking about him, like Michael Cohen and Stormy Daniels. But he was certainly not supposed to talk about jurors. That was always completely out of line. And the concern was that these jurors were out there, and we shouldn't keep them out there too long, that there was a certain danger of them being interfered with, tampered with, that they'd be subjected to the news. So I was surprised that this judge delayed the final arguments for a week. I was just really surprised by that. And some people thought that the judge got played by Trump's side, which acted like they were going to put on a substantial defense and then put on about a day at most of defense, less than a day of defense. I think the judge should not have committed himself that he was going to have the arguments next week. He should have held back on that and seen how the thing played out. And when he saw the evidence closed as soon as it did, he should have said, gentlemen and ladies, get your arguments together. We're arguing tomorrow morning. That's what would have happened in a normal case. In the normal criminal case, the pressure on trial lawyers is just overwhelming. And especially when you're, let's say, like you're one criminal defense attorney, as I am, in some cases, there'll be 2, maybe even 3 prosecutors, agents on it and stuff. Then the need to get ready like overnight, day after day, is just something that makes you a good trial lawyer or not, there's just a huge amount of pressure. You have to deal with it. You have to get ready on the facts and the law. And that they were given a week in a case like this, where there are great lawyers and lots of them on both sides, I was really surprised. And it just sort of made it sound like, well, was the judge really that concerned about the jurors being out there that long? Why did he give them a whole extra week to do this? And the idea that it would have been a 3-day weekend in between, well, I mean, my goodness, a lot of judges take off Friday afternoon. So there's 2.5 days in between. There's not a 3-day weekend in between, but there's a 2.5-day weekend in between the deliberation. So that really surprised me. In terms of how long the jurors are out, sure, a good criminal defense attorney would say, well, I know they found my client guilty, but my God, it took them 5 days to do it. And, you should take it into account, Your Honor. And the judge has heard the evidence, so that makes usually little impression. And the prosecutor says, this guy went to trial. He wasted everybody's time. He was clearly guilty, and the jury came back in 45 minutes. The prosecutor is going to make that argument on the other side. But I don't think at the end of the day, it amounts to that much. If they come back with a note, the judge will answer the note. That'll be a written answer. They don't have like conferences or chambers conferences. The judge is to have no interaction with the jurors whatsoever off the record. So the litigators will know what the question is, and they'll all agree on an answer. They may not agree on it, but they'll all confer on the answer. The judge, after hearing their arguments, will decide how to answer the questions. I expect there will be jury notes that'll be answered. And then if they come back with a jury note that we're hung, the judge will give them what's called an Allen charge and tell them, keep trying, listen to other people's opinions, stay open-minded. And if that goes on and on and on, then, after, 2 days after getting the first note that says we're hung, judges tend to realize that they really are hung. And at that point, you'd have a hung jury.
The chances of a hung jury, can you rate them?
Well,
all you need is one dissenter who just can't be moved, right, David?
I think there's very little chance that he will be acquitted of everything. I think there's a very good chance that he will be convicted of the misdemeanor.
But the misdemeanor isn't the statute of limitations up on the misdemeanor anyway?
Very good question. In which case, that charge will be dismissed because of all the misdemeanor is just sort of standing there as an underpinning for maybe a felony, maybe not a felony. So they might hang on the felony. I mean, I think they're supposed to return a verdict on the misdemeanor, which will be guilty. And then they'll go on to the felony. Now, the problem that I have with the felony, and I won't be able to hear the fact that I've listened to the case, I followed it. I'm actually here in New York, and I think that he ought to be found guilty. I think from what I've heard, if I were on the jury, I would be, I think, really fair about it, unbiased about it. And from the evidence that I've heard and what I understand the instructions are going to be, I would find that he was guilty. And I would find that he was guilty because I think that he knew he was violating and intended to violate state campaign financing law and federal campaign financing law. And I don't know if they really got into the tax records, but if they got into the tax records and they showed me that he had written off the whole $420,000 as being all a legal expense, then I would believe that he was trying to commit tax fraud too. I'm not sure they even really presented that. The problem that I have, because everyone has a right to be treated equally. The rule of law applies, right? Nobody's a king. No one's above the law. No one's below the law. So here's the problem that I have. All that they're saying in this case is that he falsified business records, the misdemeanor, in furtherance of some unlawful conduct. I think it should be specified. I think they should say to them, then find what unlawful conduct it was. The three possibilities are he knew and intended to violate, the unlawful conduct was knowing and intending to violate state campaign financing laws, 2, federal campaign financing law, 3, state and federal income tax laws. Ladies and gentlemen, the jury, if you find him guilty of some unlawful, go on and decide, was it state campaign, federal campaign, or was it taxes? And the problem that you would have, and what Trump wants so bad, and the reason he's fighting for what I'm actually thinking makes sense as a matter of law is to say, if only 4 of them think it was state and only 4 of them think it was federal campaign and another 4 think it was tax, all 12 having agreed he committed some unlawful conduct, that he would then have a hung jury because they would not have unanimously agreed on the aim. But I believe, and I know it's controversial, but I believe that they should go on as a matter of due process, as a matter of fairness in our courts. And I know people always say, well, Trump isn't fair to other people. Why on earth, Mr. Katz, do you always want to be fair to Mr. Trump? But the problem that I have is, let's assume for a second, unlawful purpose. Why would you ever falsify a business record? It's only a misdemeanor, Mark. Why would you ever falsify it? Now, you can imagine you're having a reunion. You want your friends to see how successful you are. And so you have the guy come by at the reunion and look at your business records. And they show you only made 100,000. But you put down there $1 million. And all you want to do is impress your friend. You'd be good for the misdemeanor, right? You wouldn't be good for the felony. You didn't have any bumped up unlawful purpose. All you want to do is impress a friend, okay? Come on, that is not what the legislature, so you want to hide a dalliance somehow. So you put in the business records that you were somewhere as an alibi about a dalliance that you don't want whoever's looking at the business records to know about. That's really what the legislature thought the difference was. The misdemeanor is the person who just wants to impress a friend. But anything else is a felony because anything else supposedly has an unlawful purpose. You were violating the tax laws. Why would what do you think the average person falsifies business records as a misdemeanor to do? For the unlawful purpose of misstating it as taxes. And you don't have precedents. You don't have other people like Trump who were convicted of this. And so you have a precedent over which instruction they gave. Anyway, what the judge is going to do today is not do what Trump wants, not do what I think would be probably fair as a matter of due process. And guess what? That's why I think it's very likely that Trump will be found guilty of the felony. And then that'll be his issue on appeal. Just like Harvey Weinstein had his issue on appeal and won 4-3, this will be Trump's issue on appeal, that he should have had a less vague, more specific unanimity instruction. And I think that will be probably his best issue on appeal. And some people say, well, good, that'll be very nice. That'll be after the November election. But people will see right now, and they've heard the evidence. And like I said, I thought the evidence was overwhelming. I thought Michael Cohen did very well on the stand. They were all oohing and eyeing. Oh, how could he have discussed 2 subjects in 96 seconds? You can discuss 3 or 4 subjects in 96 seconds. You can have somebody pass the phone from this body man to Trump. How long does that take to pass a phone? 1 second? So now we're down to 95 seconds. Then he had to talk to Trump. And they tried to impeach him on it. And then this Costello, oh my God. I tell you, we have 2 rival offices, Mark, the U.S. Attorney's Office in LA and the U.S. Attorney's Office in New York, right? And they're sort of known as being kind of like snooty, how great they are and how great all their graduates are, right? Well, 2 of their graduates are Rudy Giuliani and Robert Costello. I don't think that we've ever produced any alumni in the Los Angeles U.S. Attorney's Office. Anyone like those 2?
That is priceless. That really is priceless. Well, you lay it out well, just so I understand it. In this particular instance, and this kind of gets to jury instructions, because I want to ask you about those. In this particular instance, the guy who is on trial, Donald Trump, didn't have to have a specific knowledge of a specific violation that he was going to be in violation of. I'm talking about a specific law, but just a general sense that it could be one of these things. He didn't have to distinguish between state and, as you just kind of laid it out. If you, the jury, feel as though he knew he was doing this in violation of some election law, then that's sufficient for a guilty plea. Is that my understanding now?
Can you give me 1 minute? I need to turn my air conditioner on. Just give me one second.
Yeah, of course. Okay. This is a good, one of the things that I like to do is just review occasionally what I've just heard. So that's what, yeah.
I wanted to do it without the hum, but I was spritzing.
No. Make it so. So again, I won't restate the entire thing, but I guess what I'm just saying is, so the jury instruction will be, hey, Donald Trump here didn't have to know exactly what law he was violating, state, et cetera, but he had to know the general fact that he was violating some election law. Is that
he had to have some unlawful purpose. And I really mean this. I'm surprised that they didn't have more evidence. I thought Michael Cohen was going to say, I not only told him that this was, unlawful, but some law. I thought Michael Cohen was going to say, and I'm glad that the prosecution didn't put him up to saying something that wasn't true. I mean, thank God we have a country where that doesn't happen generally. But no, Michael Cohen never said, I told him, we're violating state campaign laws. I never told him we're violating federal campaign laws. Never told him, this stuff has to be disclosed, and it's not being disclosed. Of course, we're not disclosing it. We're saying the exact opposite of it.
But again, David, does he have to have knowledge of it? That's the point. Just even a general knowledge that he's in violation or not. I mean, ignorance is no excuse, I guess, is the point.
Ignorance is kind of an excuse, because if he didn't have any unlawful purpose, if he says, look, his argument's going to be, my goal in all of this was that my wife and family didn't find out, that I didn't have shame. And that is not an unlawful purpose. To avoid shame is not an unlawful purpose. And I thought Michael Cohen was going to have more detail. I mean, it was clearly shown that Trump participated in falsifying the business records. That was shown brilliantly by the prosecution, from Pecker, from the National Enquirer, through Hope Hicks. Remember when she says, I'm sorry I hurt you. Because she said, Trump had said, thank God this didn't come out during the election. She quoted him as saying. And they tried to show how meticulous Trump was, to show that he paid $420,000 and didn't know what it was for. He didn't want to pay his dry cleaning bill without seeing how many garments had been dry cleaned. They showed all that great stuff, Mark. So, I mean, I think the evidence was absolutely there. But I was a little surprised that he and Michael Cohen, nobody else ever discussed that this was a violation of any kind of campaign finance laws. That may be obvious. If you're running for president, you've got to make disclosures, and the disclosures have to be accurate. When you say that something was legal expenses, because he's got an argument on that he figured Michael Cohen was doing a lot of work, and maybe it all really amounted to $420,000. Again, they asked that great question, Mr. Cohen, have you ever seen, except on this occasion, Trump ever overpaying for anything? No, he never overpaid for anything. So he knew he wasn't overpaying. He knew what that amount was for. You have Weisselberg, the CFOs, you have his writing, which showed exactly how the money was going to be distributed. And they said, well, Michael Cohen stole from Trump. But in the context of it, you could see why Michael Cohen thought that he really was entitled to more of this and that. Look, he was a thief. He was a liar. He was a perjurer. And I believe that, of course, he had those conversations. I believe that he had that conversation that he said for the 96 seconds. And he told him then, this is exactly how it's going to go down. I just was a little surprised. I mean, as a federal prosecutor, we never would have hinged a case. And of course, the federal prosecutors didn't go on this exact same quantum of evidence against Trump under the Biden administration. They didn't go on this quantum of evidence, this whole case that they went on Trump against in state court. The Fed.
Yeah, by the way, that's worth mentioning, because Trump keeps saying it's a Biden case, it's a Biden case, Biden's behind it. Actually, Biden's prosecutors at the federal level passed on it.
Oh, the propaganda that Trump has done, the people showing up in court with the red ties, all of them, it was worthy of Saturday Night Live, which I think was the skit that they did. But no, his spin on the case has just been, terrible. I'm on some of these conservative stations, and of course, they just ask me the reservations that I have. They never ask me, what do you think of the whole gestalt? The whole gestalt is I would have voted guilty after hearing the facts of the law. But
to your point, and then I want to get quickly to jury instructions and let you get on with your day. Thank you so much. But David Katz, your whole point is essentially they did show the math. Before Michael Cohen even got on the stand, they showed the math. They showed the notes. Literally, they showed the math, the annotations from Weisselberg. And they set up the case so beautifully with their first witness from the Enquirer and the catch and kill scheme. And then, so Michael Cohen was there really as a corroborative witness. I mean, you didn't have to have the great day. Sure, he was a celebrated witness, and were he not to be there, jurors might say, well, how come the guy who arranged it all didn't make it? Why didn't you call him? But apart from that, the prosecution really did their job that way. They showed the math before Cohen even got into the box.
Well, they made a strong showing before Cohen got in the box. But and the Stormy Daniels thing, they just couldn't have the jury think, you know what? She and he never had any kind of affair. They never had any kind of liaison. And, this was all blackmail. This whole case is about paying off a blackmailer for a lying story. They couldn't have the juries have that reservation. That might have led to a couple of jurors hanging, not because they were entitled to under the instructions, but they just thought, this stinks, I'm not voting guilty. So I think that's why they had to go there. And the judge said, had you admitted that there was this encounter, I wouldn't have let this stuff in. And then she embellished an awful lot, and he didn't rein her in. That might be one of the appeal issues. And that's why it became, in your great words, so salacious and detailed with the spanking and a condom and all this sort of stuff that you just whip your head back. I know when I comment for the British media, they just can't believe how tawdry and tabloid-like the trial was. But they had to have Michael Cohen because someone did have to tell. If they don't believe that Michael Cohen ever told Trump what was going on, I think the whole scheme and the paper that we talked about, that Weisselberg did the calculations, I think it's just there's too much reasonable doubt that there's some scenario that when he didn't give him the job in the White House, he said, here's 420,000, whatever amount you put down, or you could have put 500, you could have put 130, whatever amount you put there. I'm sorry, you did help me all those years, and now I'm jilting you. It could have looked a little bit without Michael Cohen's testimony at all. They would have argued, well, this is classic, the adoration, the betrayal, the revenge. And without Michael Cohen to actually be there as a human being, and he testified very well. People have to remember that he was found to be credible in the state case where former President Trump has a judgment of $500 million. The judge in that case found Cohen to be credible, and Cohen got a little unhinged and he got angry, and he was a much more controlled witness in this case. And I think actually Costello, the one major defense witness, looked worse than him. I thought that was a terrible note that they went out on and actually increased the chances that Trump will be found guilty. So you asked me last week, and maybe you thought I was that I was wimping out. I wasn't. I wanted to see another week's worth. And from what I've heard now, I would vote guilty. And I think that they will vote guilty, including on the felony. And I think the rub will come on appeal. And I may be all wrong on this. There's not many precedents on this. And they may say, no, that's absolutely good enough. And I haven't studied the legislative history, but I'm worried about the fact that the only defense to the felony now is that, well, I just had false business records to impress an old college friend that I was making more, and I wanted to show him the books. So he'd say, oh, you're making $1 million, just like you said, and, vanity. If that's the only defense, if everything else is a felony, everything else has an unlawful purpose, Mark, right? I mean, it's so obvious that you'd be trying to cheat on your taxes by having false business records. They would just convict everybody of the felony. They'd kind of make the misdemeanor meaningless. And in the law, we tend to say they must have meant something by the misdemeanor, some really different conduct from the felony. And if the misdemeanor conduct and the felony conduct are almost always overlapping, the appellate court might have an issue with that. But it'll be after the November election.
Exactly. So now the jury gets instructions. This is my last question because we're out of time. But the normal jury instructions can vary, right? I was reading that, I always think of jury instructions as, ladies and gentlemen, you've heard all the evidence. Please consider only the evidence you've heard in this room, and please don't discuss with anyone, blah, 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 blah. And it's like a paragraph or two. It's the way I imagine it in my mind. But I was reading that the jury instructions could go on for like an hour or something. Is that, why is that? How is that? Can you speak just to that, please?
Well, absolutely. In federal court, some judges wouldn't let the jurors have the written jury instructions. So let's say they're 30 or 40 pages long and they take over an hour to read. And, one side or the other would actually want the jury to have the written instructions. And now it's become pretty normal that the jurors are given the written instructions so they can go back and they can reread, the 29th instruction that was really important. In an entrapment case, you want them to really focus on entrapment and not be just one instruction out of 50 that they hear over a reading of over an hour. But yes, they tend to be very long, especially in fraud cases, because they try to detail the statute, different defenses. They try to state them in a neutral way, Mark. But you have a right to sort of like, if entrapment's your defense, to read what is entrapment? What are the elements of entrapment? Who has the burden of showing entrapment? Does the government have to show that the person was entrapped beyond a reasonable doubt? Or is it an affirmative defense that the defense has to show? And so all that kind of stuff has to be reflected. That's what the judge is going to issue either right now or tonight after hearing the arguments. And probably that's the most fertile area of appeals, that there was a mistake in the jury instructions, because if the lay people on the jury aren't properly instructed on the law, how could they have gotten the verdict right? So it's the most fertile area on appeal to challenge the rulings below.
David, you've done it. You took us through a bunch of stuff. These are complex legal issues, everything from gerrymandering to now jury instructions in the Trump case, and you threw in a prediction as well. So Katz has paid off. We'll listen and watch for you across the spectrum of media that you do, and look forward to your meeting. When are you back out on the West Coast? Are you coming back next week?
I'm coming back in a couple of days. I'm not going to be here next week for the arguments, but of course, I'll be, the crazy way we have to watch them without the trial being televised, where all the presenters are sort of looking down and they're trying to be, animated and everything, but they're trying to read the little summary at the bottom. I'm going to get it that way like everyone else. But I've been on Fox 5. If anyone's in New York, Fox 5 is a huge local station here, and I've been on with them quite a few times. One of their reporters is on the buses going by, so I've been with a lady on the bus on the 10 o'clock news here. So it's been a lot of fun. Looking forward to getting back to California real soon.
Yeah, we hope to see you out here soon. All right, David, thank you. Safe travels. David Katz, everybody. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.